Welcome to this episode of the Justice Team podcast on the Justice Team Network. And today we're talking about probably the most important thing in trial and probably the hardest skill set to learn, and that is jury selection. We're very honored here to have Harry Plotkin, who's probably the most world-renowned jury selection dude. Was picked 7, 8, 9-figure. Have you had a 10-figure one yet?
I have not yet.
Ooh, the lucrative 10-figure.
So it's coming.
It's coming. But Harry and his wife, Claire, we've picked many juries together. They do a lot for a lot of the most well-known trial lawyers. And I know your wife is picking one right now.
She is. She's picking her third of maybe 4 juries this week. So we're in the courtroom as much as judges will let us try cases.
So Harry, just give us. So I'm going to tell everybody who's listening. Here's kind of the topics we're going to go through. So we're going to talk about kind of what's called 4 cause challenges, which you should know, depending on your jurisdiction, but it's probably the most important thing to know how to get bad jurors off your case. We're going to talk about kind of like your tone, your effect, what you wear. We're going to talk about if you're picking a jury for what we call liability purposes versus damages. We're going to give exact questions that sometimes Harry likes to pass me a note of to ask a specific thing. We're going to talk about what work goes into prior to that jury walking in to make sure that we have the right skill set to go into it. And am I missing anything?
Yeah, we can talk about some common mistakes and things we've seen that because it's like everything in trial. One time you step in it is like you've undone a lot of the good things you've done. So you got to make sure that you're not doing anything dumb in jury selection.
So Harry, are you and your wife lawyers?
We are not lawyers. We are just people with regular people with an expertise in psychology, and really it's focused entirely on the weird little unique thing about jury decision making. We're not like marketers, advertisers. It's just when you get in that box, and most people who are jurors have never done it before. It's just how are they going to react to cases?
Yeah, and you've picked juries for personal injury cases, product cases, employment cases. What kind of other stuff have you done?
In the past, I used to do everything: commercial cases, patent cases. I still, on occasion, will do commercial cases for friends, but I really these days just like to focus on PI, employment, consumer things that matter to real people. I don't really like to get involved as much when business disputes and things like that. Yeah,
you had an employment one for 9 figures. I think that one was the Tesla one. You've had a lot of really big verdicts recently that you or your wife had selected those juries.
Yeah, I mean, employment is a lot of fun, but yeah, PI. I mean, last year I had a $150 million wrongful death case with a great lawyer, Jude Basile, in Palm Springs, and David D. Robertis said that $464 million one against Southern California Edison. That was a 2 plaintiff employment case. One of the plaintiffs got 440, so not too bad for him. But
yeah, so let's set the table first. So wherever you're picking the jury, it's also important to know your jurisdiction and what are your rules for jury selection. So the first one is, how many jurors do you have sitting there? Are you able to actually select or ask the questions to the jury? Because sometimes if you're in federal court, you don't get to ask a single question. The judge does all that for you. And then you have to know, do you need 9 out of 12, 8 out of 8, kind of those things going in, right?
Yes, absolutely. I mean, different rules in different venues, and even different judges have different rules. I've seen judges, give you 15 minutes and you can't even ask them things like their hobbies, and some judges who just sit there and fall asleep for 3 days and let you drone on and on, which is not necessarily a good thing either. You want to be efficient with your time. I know, Bob, you're amazing at being efficient and respecting the jurors' time, and they respect you for it. So you got to walk that balance.
Yeah, and it's a lot of, sometimes, we know judges are going to give you no more than 30 minutes to qualify like 90 jurors. Some judges will give you a long time. Some don't let you ask certain questions, right? So it's important to do that homework. So let's talk about that homework we do before we get there, Harry. So what are your dream scenarios before you walk in to pick that jury? What are some things that you like to have seen the law firm do?
I always have to get up to speed on the facts of the case, and especially what the defense is going to say. I feel like I can't pick you a good jury unless I know exactly what the defense is probably going to say, because we're really trying to look for people who are going to get pissed off by what they say and get rid of people who are going to agree with whatever they're going to say. And if they're being unreasonable, it's a lot easier. But if they're being kind of reasonable, or they're making some point, or they have some kind of defense, you got to know, who's going to be, which jurors are going to just kind of be receptive to what they have to say, or not get angry. Because my goal is to get you a jury that's not only going to be siding with you, but also going to be really pissed off by what the defendant did, and even more pissed off by how they're defending the case. So I need to know all of that stuff. And then, I'll come up with the key voir dire questions and topics. And usually I always like, I mean, for the most part, there's always at least one really key open-ended question that I like to write for the lawyers, and I have them ask every juror there if we have time. So I can really just gauge each and every juror one by one and say, is this juror going to get pissed off? Are they going to take this case seriously, or are they going to buy the defense BS?
But before you get in there to get that critical question, I know we've done a lot of focus groups prior to getting there to kind of understand the exact nuances for your case. So you can walk us through, the ideal scenario, correct me if I'm wrong, but if you're able to do a focus group or two to narrow the issues, narrow how human beings, the ones we're looking for, and then if we can find a way to have the judge ask a lot of questions or do a jury questionnaire, is that better for you than walking in there, dry powder? Just give us kind of that workflow, what we do before we get there to see the white in the eyes of the jurors.
Sure. Yeah. I mean, certainly if you can in a case, focus groups are great. I mean, not only to kind of figure out what jurors are focused on and what's pissing them off, what's not pissing them off, but also the things that you're doing that, is your focus in the right place? Are you making, even if you're making one argument that it just is not resonating with them and you're losing credibility, it's like drop that claim, drop that part of your case. I mean, I've had cases where they're great cases, but maybe one of the 10 arguments is like, don't say that because you say that. It's like the 13th chiming of a clock where it just makes the jurors question everything else. And
so how do you are these online? Are they in person? How are you running these focus groups?
I do kind of all depending on what you're hoping to learn. I do online case studies for if you want to kind of get some profiling and 50 or 100 jurors. I do really like to do the in-person and Zoom ones too with attorneys presenting the case, just so you can kind of get practice, a sense of how you
practice.
Exactly.
Practice.
Exactly.
Let's talk about practice.
I know, exactly. Practice. And also helps, it helps immensely to do the other side or whoever's doing the other side. Because then you start to figure out, oh, you know what, maybe there are some weak spots in the case.
So what I do when I do these is I always like to play the role of defense or a defense expert and try to win the case for the defense.
Yeah, the expert is key. We've had a couple where you did the expert, and that's and that's not only a lot of fun, but it helps you to kind of understand, the expert is the one who could really hammer you because the jurors are like, this guy's an expert. I mean, who am I to question this person? And so you got to test. I mean, sometimes I call focus groups, you're crash testing your case and seeing, is it going to crash? And you're hoping that something falls off so you can fix it.
Yeah, we did a few and we kept crashing so hard that we resolved that case, and I knew it was a wobbler. But yeah, so we do the focus group. We have some information. You have that critical question, that open-ended question. What are some examples of an open-ended question that was like material in a case that you've had? Sure.
So I always like the structure of, what are your feelings about whether, X or Y, and kind of it's open-ended enough that there's no yes or no answers. Because when you ask a juror a yes or no question, like, do you have a problem with medical malpractice lawsuits? Do you have a problem with damages or whatever? It's really easy for someone to kind of say, no, I'll do what the law allows. But it's really hard for a juror to lie if they have to kind of explain how they feel. So like, for example, in that big Edison verdict, the key question that I had each juror asked was something along the lines of, let's say a company does a great job, in the workplace of having good policies and training on the rules and everything like that. But, what are your feelings about whether they've sort of done enough for employees to behave themselves, or whether the company should have to police and monitor the workplace, And so we had some jurors that we struck that were like, what can you do? You can't stop people from doing what they're going to do. All you can do is train them. And the best jurors were the people who were saying things like, oh no, rules are nothing, policies are nothing if you're not making sure they're being enforced. You should expect these people to go crazy. So you gotta do something. So it's always some question that really gives me a good insight into the values that are going to matter in the case. And you got to make it open-ended so that they have to explain. So like I said, so that the people who are cagey, they're bad for you if they don't really want to answer a question.
Yeah, and that also helps you set maybe a theme for your case too, that they've psychologically now been tied to. So if you ask that open-ended question and they're like, well, yeah, the rules are there, but you still got to make sure that they're followed. And then if that's their psychologically the first thing in their brain when they're jury selection, and then that's your theme, and then they're like, well, that was what I said, so of course I agree with it.
Exactly. And the defense gets, when you start having juror after juror saying the good thing, answering things the good way, it scares the defense, and they can't strike them all. That's the goal.
And I found a lot of defense lawyers, now there's a very top tier, top 1%, but most just ask, by a show of hands, who agrees with this? Yes or no, do you agree with that? And they just ask, 20, 30 minutes of yes or no's or just talking to the jury, and they get nothing out of them.
Oh yeah, they like to lecture. I mean, they like to get sympathy. We go last all the time, and you're going to use your common sense. I mean, the funny thing is with defense lawyers, I found that they really think that any juror who is logical and not emotional is going to be good for them. They can't imagine a scenario where a logical, rational person is going to get pissed off at what a company did. I mean, it's shocking, but that's what they think. They think, oh, if you're just going to listen to the evidence, you're fine. It's like, have you listened to the evidence? Have you looked at the evidence in this case? So, so I'm most worried about jurors who are, I mean, honestly, the worst kind of jurors are the ones who are super cynical and jaded about this kind of stuff happens all the time. Who cares?
Yeah, and I find there's people with certain emotion, the people with the lack of empathy that are just super, unempathetic, buyer beware, kind of the F your feelings type crowd. They're not going to be a good juror for me. Maybe on liability if I got to follow rules, but otherwise they're like, yeah, whatever, who cares? It's not my problem. So here's, so we talked about some of the stuff we do before. Sometimes you're lucky enough to have a juror questionnaire, give a little more insight on some critical issues, which you can help. And if Harry and his team write some of those for us, some critical questions we submit to the judge. A lot of times you're not that lucky. You have to be there to pick in the moment. So before we walk into the courtroom, are there any suggestions you have for our listeners and viewers on stuff you should wear or things that help jurors open up more? Do you believe in that?
It's probably not as important as some people may think, but, I wouldn't try to dress too flashy or I wouldn't look too corporate at all, especially if you're suing. I mean, well, either way, if you're suing an individual who's got an insurance company lurking in the background or you're suing a company directly. I mean, I think you want to be approachable and, you don't want to be wearing some power suit or Rolex or anything.
How about an all-white suit with a red bow tie?
Ooh, I like that. I mean, if you're in the South, go for it. Some jurors, in the South, jurors really like that. It's funny, the regional differences. Like, if you're like some big, colorful attorney in the South, Southern jurors tend to love it. You come to bring that to Los Angeles and they're going to just hate you. And it's just weird. And it goes vice versa,
So one jury that we picked together in San Bernardino, we showed up for jury selection day, and we were wearing the exact same thing. We both had on like this khaki brown suit, a yellow tie. So we'll drop that in the episode. I'll find that picture. We showed up. We're like, really? We are wearing the same thing here? But I personally like to wear very soft, warm colors. So usually I pick jurors in yellow or orange ties, wear like a lighter colored suit, never a black. I never wear black suits. Never wear black suits, never wear black undershirts. It's always white or light blue. You want to be approachable. That's just how I generally.
Yeah, just don't look corporate. And that goes for, plaintiffs and, witnesses. If you have somebody, sometimes plaintiffs think that they should show up in a suit. I would tell them, don't wear a suit. No. Even if you're the CEO of a company, don't wear a suit. You should just be approachable. And it's just because it's court, you should be respectful. You shouldn't wear jeggings or cut off, jorts for a guy. But, although,
I would love to have an all denim suit to pick a jury.
There you go. Exactly.
Some bedazzled stuff on them. But I'm a big brown shoe guy or cowboy boots guy picking a jury. I never wear the black shoes ever.
Yeah, I agree. I love it when the defense shows up looking super, super corporate because not only, the jurors see them and they're just thinking, okay, there's a lot of money behind this case, there's a lot of money behind this person. This is just a big, corporate shill, especially when they have the insurance adjusters in the back on their laptops. I just had a jury a week or two ago where one of the jurors said, can I ask a question? Like, who's that guy in the back with the laptop? And they were like, oh, and it was like some city's in-house counsel, but they were like, she was like, the one with the laptop. Like they notice, people in the back wearing the corporate suits with the laptop. Like, who are these guys in the back? And so you don't want to be the side that looks all corporate.
And I've been in trials where I put up a witness for the defense, and I ask like, who's that guy back there? And that makes them like, oh, the whole courtroom looks back like, well, who is that guy? Is the guy I saw him fall around the jurors? Who is that guy back there? It's really funny. But anyway, that's once you get into the case a little bit. So I also like to wear. I'm a cufflink guy, but again, not flashy. But I like to do things that resonate with the jury, depending where it is. Like if I'm in Texas, I'm wearing the Catholic cross cufflinks. If I'm in a place like San Bernardino, I have one that says "Don't be a dick," and if they see it, it's really funny, or whatever. So anyway, we talk a little bit about that. So as you walk into the courtroom, just so people understand, usually it's the judge asks a series of very typical questions. You're starting to get a read on it. We're walking into something here. There's two different ways to get rid of a juror. One is for cause, which doesn't count as what's called a peremptory, which each jurisdiction usually has a set amount of peremptories which you can get rid of for any reason. Some jurisdictions like Arizona don't even have those. You can maybe have for cause ones only. So there's a very important skill set to how to get a juror off for cause. And that is that they are so one-sided or unfair that they cannot be on this jury. And we are seeing this while we're doing this podcast, they're actually picking a jury in the criminal trial for Donald Trump. We're seeing a lot of jurors that cannot be fair. They've looked at their social medias, and that's how you're getting them off. So a very skillful lawyer will not count against their peremptories, which usually you can have 6, 8, 10, depending on the jurisdiction. It doesn't count if you get off for cause. It's like a free strike. So I'm of the mindset of we have to identify the poison on that jury and jury deselection, get them off.
Yes.
So first, there's something called a mini opening, which we're allowed to do in California. So walk us through the mini opening, because this is going to be tied to for-cause challenges.
Oh, for sure, yeah.
So walk us through what a mini opening is and how to use it successfully.
Right. So a mini opening is before you voir dire your jury and ask them anything, rather than this boring 2-sentence neutral statement of the case that the judges would typically read. At least here in California, and I'm sure in any state, I mean, you can, even though you may not be required, the judge might not be required to do it. I mean, try and sell the judge on it. Hey, this makes jurors more interested. It gives them more context. They're short. I mean, here it's like 3 to 5 minutes typically. Judges who don't like it in California, but they know they have to, will try to say, you have 1 minute and I'm going to cut you off. But still, I mean, any time is good time. So, but you're basically giving a little quick mini talk about what your case is all about. The defense gets to do it too, and but there's a real specific strategy to it, because it's a jury selection tool. It's not an opening statement. It's not a time to persuade your jurors, because the danger is if you tell them the good facts in your case, you're just going to lose a bunch of jurors for cause, and you're walking right into what the defense wants you to do. And so you're hoping the defense does that, but the way that I do it in a nutshell is that you need to share all your really bad facts. If you have like 1 or 2 or more bad facts, I mean, throw out all the bad facts in your case. You're going to hear in this case, my client did nothing wrong with driving, but he had 3 beers before. That's something you throw out in your mini opening. Something that you're going to then turn around and voir dire and say, hey, given this one fact in the case, is there anyone who thinks like you're cooked, like I can't be fair?
Yeah, and that's a polarizing issue to be able to see how they feel to get them off. And I think that's where a lot of defense makes a mistake, is they do a mini opening and they just do their opening to try to argue their case. They're not identifying any of the bad jurors. They're just like trying to like win the jury rather than pick the jury, which is what you're actually trying to do. So here's an example, and I like to do it where you're not saying this is a true fact of the case. You're saying this is what the other side is going to argue that matters, because you're not very true. So it's like, if we have a case where generally we're going to likely be offering for, asking for millions. Sometimes I definitely say that because you can get jurors off for cause,
for sure,
because they cannot compensate people for pain and suffering, emotional injuries. I like to, if it's a liability dispute, like if somebody has alcohol in their system, if they're on methamphetamines, if they have a prior felony conviction, I get all that out there. So put your bad stuff and be upfront about it.
Yes.
This case is a simple car crash. My client's we're going to ask for compensation in excess of $10 million. You're going to hear about all their injuries. They're significant. Again, I'm not going to tell too much because I don't want to have my good jurors say, well, I had, my so-and-so brother-in-law had this issue and I can't be fair because of that. Now we get the bad facts. But you're going to hear from the defense that they're saying that the case isn't worth in excess of $10 million because my client had alcohol in their system. My client had a felony 15 years ago. And they're also going to say that they're not responsible because of XYZ, right? Now we've identified 4 or 5 issues.
Yeah. Pre-existing stuff. Oh, you're going to hear he had another car accident 3 years ago, and that he had some injuries, but we're going to tell you, I always like to contextualize it just so that they know there's another side to it. But you're going to hear from their doctors of whether those injuries were even minor or major at all, have anything to do with these injuries or something like that.
Yeah. And then once your turn, after the judge goes, get back on those bad facts and pick out a jury, which you can see some body language, how they're answering questions with the judge. Who is going to be a bad juror for you?
Yeah, I mean, your goal is to, at the end of the mini, is for all the bad jurors to say, I've heard enough, your case sucks. Yeah. And I got an issue with this or that. And for all your good jurors to say, I'm kind of curious and I don't know whether this is a good case or a bad case. Now, you don't want to tank it so much that you just make it sound like a piece of shit case, because that's a big mistake too. So the way that I do it, rather than... don't tell any of your good facts, just allude to them. So if, like, for example, if you have a case where, it's a sex abuse case and one of your best fact is like, you would normally say in your opening, you would say like, this school district heard 2 years before another student came and said this teacher was touching her in the butt or something. Don't say that in your mini opening. You're going to lose all the good jurors. Oh my God, I can't believe this school did that. You just want to say, you're going to hear evidence of what the school may have already known, what they heard, what they did, what they didn't do, so that the jurors like, are thinking, well, what did they know? What did they? And you're going to tell them in your opening, but save that for your opening. Just kind of allude to like, you're going to hear what the doctors have to say, or you're going to hear this, or you're going to hear all, what you're going to hear, what this company knew about their product, and if they did safety testing and what their safety testing showed them, and just allude to it. But you want your good jurors to be like, I have no idea if this is good or bad, but I'm kind of interested in this case.
Yeah, again, you don't want to try to overly win your case because you get rid of your good jurors. And if you have a bad fact, you don't want to have your bad fact the first time that it's said is an opening statement, because these jurors that probably could have got off for cause are sticking around. Yeah. And when you walk them through getting off for cause, again, check your jurisdiction. There's case law that says some key things to be said. I'm of the mindset is you should have a couple of people picking the jury with you, whether a consultant or another lawyer in your office, that you should be engaged in listening while you're asking the questions. They're writing down verbatim things that these jurors are saying that gets them off for cause for not being able to be fair, and walk them down that path. And if it's a juror that is good for you, I try to preconditionally rehabilitate them to say that they can be fair. So why don't you walk us down first? Let's say that we've identified a very good juror that if the defense tries really hard, they might get him for cause, but we think there'll be a good juror, and how are we able to help arm the judge with things to keep them on?
Right. I mean, that's a huge, especially these days where I think our jury pool is a lot more friendly than it was 5 or 10 years ago. Prehabbing jurors, and I call it prehabbing because you're not really rehabbing them. You're going first as the plaintiff lawyer. And so the defense is going to get that last word. And if you let a good juror think that a feeling that they have or an experience they had maybe a bias, they're going to be gone. So you need to, before the defense even gets up there, you need to think, okay, who are the people that this defense lawyer is going to think, I'm going to get these people. In a sex abuse case, I'm going to get every single person off who's been a victim or knows a victim. I'm going to get everybody off who has strong feelings about, child abuse. Every person who works with kids and loves kids, everybody who's sympathetic. I'm going to, whatever it is, whatever the case involves. Like I have a one right now against a slumlord. I'm going to get off every single person who's had a lousy landlord and hates landlords. So you got to think, okay, how do I protect those people? And the way is that you have to get up there, and there's a way that I do it, and I can happy to send it to anybody if they get in touch with me, but it's you have to convince them that's not a bias. Because it really, to me, I got to tell you, it really isn't. And so what you do is you have to tell them having strong feelings is not a bias. There's a difference between a conscience and a bias. If you get upset at things in the world that are wrongdoing in the world, that's a conscience. That's not a bias. So as long as, and one important thing to tell jurors always is, jurors are allowed to get upset at the evidence they hear in trial. Getting upset about something is not a bias. So as long as you can wait for the evidence and let the evidence decide for you if you have a reason to be upset about what this defendant did, that's the job of a juror. And so you gotta address them often before they even raise it. You need to say, hey, how many people here have been mistreated by a company in an employment case? Or how many here have, sadly had an experience with sex abuse or something like that? And you got to walk them through it and talk to them and explain to them why it's not a bias and say, can you do that? And you don't say, can you set it aside? Because once you say that, you're kind of telling the juror it kind of is a bias, and people they know I can't set that aside. But you just say, can you decide that just because you've been a victim of something before doesn't mean that you don't know right from wrong? And you're allowed to,
and that I do the same thing when you ask those questions of that juror that you want to prehab.
Prehab, yeah.
Have you ever been to prehab?
I have, yeah. I've had a couple stints in prehab.
Yeah, so I go to that juror and say, when His Honor was talking to you about, being a part in any other car crash or being part of a lawsuit, you raised your hand, you talked a little bit about that, and you said you'd left a sour taste in your mouth for certain sort of people and companies. So I just got to ask you, do you realize, that's based on a certain set of facts that happened to you? They're like, yes. And I said, no, in this case, we haven't heard any evidence yet, and if you find that this company over here did everything by the book, they did everything right, can you be like, well, that was my experience, but in this one, they did nothing wrong. Can you do that? Like, yeah, I could do that. So as we sit here today, we haven't started, and are you like, you guys are even, I'll wait for the evidence, and that was your experience, and it's separate, but you can follow the law? Yeah. So again, you're using those key words the judges want to hear. You want to hear verbatim. When they go back and make a for-cause challenge, you're like, well, they said they could be fair in this instance. They said they could not talk about their issue. They could segregate the two. They said they'd wait to hear the evidence in this case.
Yeah.
That's what the judge wants to hear.
And really what you're doing is you're trying to convince, I mean, the judge loves it too. Judges who don't like to grant cause love it when you do that too, by the way. But one thing that you're trying to convince the juror that those feelings that they have that's not really a bias. And so another line I like to say to those jurors is to say, so, has that experience that you've had that you're talking about, that you're concerned about, has that made you feel like, when employers treat workers unfairly or when schools don't protect kids from abuse, they should be held accountable? And they go, yeah, damn right. And you go, that's exactly what the law says.
Yeah.
That's exactly what the law says.
Yes.
You're allowed to hold them. So, that's the job of a juror, to hold them accountable
We
if
could
they
do a
did
whole
something
course
wrong.
on prehab and for cause. So you're just doing this, basically as we can. So it's like, hey, we got, I like to walk into the jury, judge does their thing. I walk in, and first thing I always get up and say, we've heard a lot of people that can't serve on the jury because, they have other commitments, or maybe it's not the right type of case to hear, but who here wants to be on this jury and sit here for 3 weeks? And it always gets a laugh. You always get a hand or two. Those people generally are good plaintiff jurors because they're interested. They want to serve. They're not there to screw somebody. You talk to them a little bit, and later on at the defense, they'll likely try to kick that person off, and the jury hates when they do that because they wanted to serve and they didn't. But then I usually go right to somebody that is probably so pro-plaintiff, and they said some things that were obviously going to get off for cause. And I start with that person. I say, look, we want a fair jury here, and I heard a lot of things about what your husband went through, and they had the same type of surgery, and I saw you were crying. Can you share with us a little bit more about how that injury affected everybody? Now I'm preconditioning the whole jury because she's not going to be there, but I want them to hear from her about how bad it was for her. She's going to talk about it. I know she's going to get off her cause. And then I'll say, look, we want a fair jury here, and would you agree that as you sit here today, you're probably going to let your sympathy override your everything else, and you can't be fair to the defense? And they'd be like, she's like, yes, that's how I feel. Like, you know what, Your Honor, defense, I will stipulate for cause. Do it in front of the jury in credibility. And then I go right after the people that I know I can likely get off for cause. So let's talk about getting people off for cause. Common ones we have for that aren't able to compensate human harms or emotional injuries. So walk us through some things you do, because you could feel it when the judge is asking questions. Who's not able to do it, and go after them.
Yeah, exactly. I mean, yeah, there's obviously liability reasons and damage reasons. I mean, damage, every case, everyone who does civil cases, whether it's employment or anything, it's damages. And so, I always like to, the way that I frame bias is, a bias is something where you're saying, essentially, no matter what the evidence shows me, I can't do this, I can't do that. I don't like this law or whatever. And so, for damages especially, I like to just say, are you open-minded to the possibility that someone's, quality of life could be worth millions of dollars? That's one I love to ask. Or, and you got to say this part, or do you think that just sounds excessive or unnecessary, no matter how injured somebody is, or if it's like, just a back injury, for any kind of a back injury, if the person's not in a wheelchair or something. And, when you get jurors saying, yeah, I don't know about that, you make it really clear to nail it down. And you're saying, this is without hearing any evidence, is like, Mr. Simon, like nothing that you show, nothing that this person says about how it's affected them could be worth millions. So they're basically saying the evidence doesn't matter. Now, if the evidence does matter and somebody's sympathetic,
And remember, the defense is going to try to get up there if they're smart to rehabilitate them.
Yeah, could you follow the law? Yeah.
But again, this is where it's important to, once they affirm that they can. So I walk them down that path too, and invalidate, say, and it's okay you feel that way, because we want the fair jury. We heard about Mrs. Jones who can't, and I just want to know, we hear Nick Riley talk brutal honesty. I say, in your heart of hearts, as you sit here today, and you could just be honest, in your heart of hearts, if the other jurors say this case is worth $10 million, are you going to be like, nope, never going to do it? Just tell me what you feel about it. And they'll start talking about it and say, look, the judge will instruct you about something called burden of proof, and we have to prove more likely true than not true. That's like 50.01%. Are you going to hold that same standard to when it comes to asking for $10 million for pain and suffering, stuff you can't see? Are you going to want to see more? Like in criminal trials, you're going to do I got to be able beyond a reasonable doubt. Do you want to see a higher standard? And they'll be like, absolutely. And say, no, when the judge asks you if you can follow the law, I want to be clear here. When you say you can, you want to see that higher standard. And they'll say yes. So that's why I get them to commit on not being able to follow the law, just on the burden of proof question.
Exactly. And yeah, you got to anticipate that the judge or defense counsel is going to say, well, you'll follow the law, right? Whatever the judge instructs. So I think the key to really locking them in and making them rehab proof is to say something along the lines of, now, I'm sure that you're going to try your best But are you telling me that even if you try your best, you think it's going to, you have some pretty strong concerns that that's just not going to happen? And when they say, yeah, not only does the judge hear it and it's on the record, you could probably argue for it anyway, but then when the judge and the defense ask them that, they start to kind of say, well, like I told Mr. Simon, I'll try, but like I told Mr. Simon, I don't think trying is going to be enough. And when you get them to say that, they're locked in. The other phrase I love is, I always like to say, I never say, would you have a hard time being fair? Because everybody thinks they're fair. I love to get them to say, are you telling me awarding that much money is going to be an uphill battle? And they go, yeah, pretty steep, right? Oh yeah. Like, I'm in a hole here. I'm going to have to dig out. And once they say it's a steep uphill battle, it doesn't matter if they'll try. I mean, they're telling you that you're handicapped and everything.
And some jurors, they're smart and they realize that if they say and agree with you on these extreme things, they're going to get off this jury.
True, yeah.
so I usually say, as a judge, a famous judge from Texas once told me, if you talk, you got a chance to walk. So let's talk a little bit here. They start talking and say, who else agrees with this person that might not be a good juror for this case?
Yes.
Who else agrees with this person? Tell me more. Let's talk about it.
Yeah.
You don't like high damages. You'd think if somebody has alcohol in their system, they're going to get 0 no matter what. Is that how you feel? Well, tell us why, right? And so you want to arm yourself. So we could do a whole show on for a cause, a whole demonstration. It's a deeper issue topic, but those are some general tips to be able to do it. What are some common mistakes that you've seen, Harry?
One of them is when it comes to cause, it's like I've noticed in the last, several years, as cause has become more and more of a thing that people are getting really good at. It's kind of like, you see somebody coming from the gym and like you ever see that Simpsons episode where Homer's just working out his right bicep for arm wrestling, and he's got this big old right arm and his little wimpy little left arm? It's like a lot of lawyers these days are really getting good at exercising that muscle of cause, but they kind of are forgetting how to just, to the rest of the jurors, talk to the rest of the jurors. And so everything is just like talking to the jurors and then immediately just, can I get this person for cause? Can I get this person for cause? And not just listening to them. Because some of these people, who may have, I've had this experience, that doesn't necessarily make them a bad juror for you. You only really want to lock in on somebody when you're like, okay, I'm pretty sure this person is going to be bad. But one thing a mistake that I see make is lawyers judging jurors kind of a book by their cover thing, saying like, well, this guy's an engineer, I need to get him off, or this person, has had this experience, so I got to get him off. He's been sued before. Or he thinks, there's too many lawsuits. Like I think it's a big mistake if you have a pretty good case to ask about, are there too many lawsuits? Do you not like frivolous lawsuits?
I think there's too many lawsuits.
Yeah, I do too. And it's like, what? Like, who doesn't hate frivolous lawsuits? When you say the word frivolous, who doesn't hate frivolous lawsuits? And I've seen it a million times where lawyers will ask that question, which in a good case, I think you don't even need to ask that question. It doesn't tell you anything. And then they try to get someone off for cause. And the person's like, well, I don't think this case is frivolous. But the lawyer hasn't been listening and they're still trying to get them for cause. And you're like, they're great jurors.
And another big common mistake I see is trial lawyers try to win over every single person. And when they see a juror that's really bad for them, and they're really bad for you, don't try to win them over and win your case.
That's true, yeah. They're pushing back. Yeah. But if I prove my case, I've seen this question like, now if I prove my case that this is worth $50 million, are you going to not be able to award? It's like, what is that question? In their mind, like, of course, like if you prove, that's such a hypothetical for that person. They're like, okay, yeah, sure, I'll give you $50 million if you prove it. And what they're telling you is like, good luck,
Yeah, and I've seen lawyers push it too far. It's like, you got this person for cause, stop. And then they'll keep going and then try to rehabilitate them. And then all of a sudden they've said something that like, now you don't have it for cause anymore. And I've seen trials I just shake my head like, why would you do that, man? Why?
And it's usually by saying, so you couldn't be fair. And they're like, well, no, I could be totally fair. Oh, but you're saying that you struggled to follow the law. No, I could follow the law. And now you just went right backwards. So yeah, but I always like to teach, no matter what your jurors' jobs are or whatever, they're human beings first, and they're engineers or nurses or whatever second. I've seen so many great engineers, nurses, any occupation. And anytime I hear a lawyer say, I would never keep this kind of job or whatever, I always just shake my head and go, you may be right 6 out of 10 times or even at 8 out of 10, but that means that you're probably striking some really good jurors.
Yeah, and then we gotta close the episode off here, but in general, I'm looking for jurors. We do a lot of research too. As they come in, you can look up information on them. You should see who's coming up next in the box, strategize your strikes to be able to get that best juror on there. That might be the 4-person, et cetera. That's for another day. I generally like jurors that are logical folks that are not conspiracy theory type people, logical folks with empathy. If I can find those two things married together, that's kind of what I'm looking for in a juror.
Yeah. For me, the sweet spot is someone that I call a Boy Scout, could be a Girl Scout too, but somebody who is takes safety seriously, or the rule trucking seriously, or the rules. You gotta do your job, and they're gonna be pissed off when they hear somebody cut corners or was sloppy. And a lot of times those people are professional people, and so the defense will keep that person like 9 out of 10 times.
Dude, my biggest trucking verdicts are when they kept a trucker on that case.
Oh yeah.
Oh boy, they get so mad. Remember the one we had one jury trial with this guy, and the defense thought he was so good for him. He's the one that wanted to give us like $30-40 million, but he was wearing shirts that came in. He was a trucker, came into court. It was a trucking case that said his T-shirt said like,
"Let's go, Brandon."
Let's go, Brandon. Yeah. Like every shirt was like a pro-Trump, like. But we were talking to this guy, here, we were like, I think this is our best juror. So we were like tricking the defense to think like we wanted to strike him and all these things. And then when we agreed to the jury, they were like, oh, we got him. He's on. They tried to trick us. They're like, we agreed to the jury. Like, well, so do we, you idiots. And this guy, exactly. He was back there fighting for us. Oh, man, I'll never forget that.
But those are the best jurors, because ultimately at the end of the day, I want people who are going to get pissed off. Somebody who's just, if you win a trial technically and the jurors are like, it's not a big deal, but technically this person was negligent, they're not going to give you a huge verdict. You're going to get your big verdicts from people who are genuinely pissed off. And so you got to have jurors on there who are capable of being pissed. They have to have a conscience. Yep. And if you get people who are like, not a big deal, you're just not going to get
and to get them pissed off, even if they're admitted liability, it could be the way they're treating your client. It could be the way the defense is handling them, the way that they're treating them. It could be even the defense experts. So, Harry, thanks for coming on. How do people reach you?
They can shoot me an email, harry@yournextjury.com. They can go to the website. I'm sure all my contact information is there. So happy to talk to any folks who've got a jury coming up.
Thank you. You have your OnlyFans account. Can you give out?
You got to actually subscribe just to get the name of it.
Oh, that's
that's how I make the big bucks. Yeah.
Very sneaky. Well, Harry, thank you for coming on for this episode of the Justice Team podcast on the Justice Team Network. Go to justiceteamnetwork.com. If you have any questions or concerns about jury selection, we'll get hold of me or Harry. We'll get right back at you. Try your cases, folks. Ciao.